Good afternoon, and welcome to the first of our series of webinars. And we've got an exciting series of topics for you. Today, we're going to be dealing with successful closing strategies, mastering the sale. On the 21st of March, we're going to have a session devoted to the APS, and we have another session coming up on the 25th of April. In our March session, we will have a special guest, which will be my good friend and former Bencher colleague, Bob Adorian. And Bob is a lawyer at DeVray Smith. Thank you for the many real estate agents and also lawyers who are joining us today. This session will focus primarily, though not exclusively, on what happens after the agreement of purchase and sale is signed. But we will also touch on a few pre-APS matters as well. So in terms of the agenda for today, we're going to identify some transaction pitfalls. We're going to review top client complaints. We're going to talk about strategies to ensure on-time closing and client satisfaction. And finally, at the very end, we'll have time for a little bit of Q&A. So if you have any questions, please don't hesitate to put them in the Q&A box, and that we will try and get to them at the end. So my name is Geoff Pollock. I've been a real estate lawyer for a decade and a half. I'm a former bencher in the Law Society of Ontario, a former member of the LSO's Real Estate Liaison Group, and I'm the president and CEO of MASTERRE. Most importantly, I am a championship-winning professional hockey coach, or at least that's what I think of myself when I'm driving to my daughter's game, which I coach the team. Though the championship part is absolutely accurate, we did win the championship last year, and we are deep in the playoff push this year, and we have high hopes. And you will notice that my cup right here is I am goal-oriented. So let's talk about some of the factors that impact upon transaction closing. Well, we're going to discuss the closing date. We're going to discuss financing, incapacity or death, disaster, and also title issues. We're going to offer suggestions on how to reduce the chances of the transaction not closing on time or not closing at all. So we're going to start off with the closing date. There are three types of closing dates that you want to avoid. The first is before or after a long weekend. Now, long before the COVID epidemic, the banks were suffering from the long weekend epidemics, and so many people would find themselves developing a cold immediately before or immediately after a long weekend. And this creates all kinds of challenges. And in my experience, that those transactions that happen either immediately before or immediately after a long weekend, about 10% of those deals don't wind up closing on time. So it's a similar story in terms of having the deal close on the first day of the month or the last day of the month. These 2 days represent about 35% of the transactions for an individual month. And the banks can find their back offices overwhelmed. It can make it very, very challenging for you to, as a real estate lawyer, to receive instructions in a timely manner, or even for the deal to get processed. In my experience, perhaps 5% of these deals don't close on time. Now, the final one is trying to buy and sell on the same day. And there are a lot of clients who may be interested in this, but in terms of the people who are most interested in the transactions on the same day, this is generated by the moving companies. And they love it when people try and buy and sell on the same day. So, because what essentially your clients are going to wind up doing is paying for the movers to sit around and drink double after double after double. So you have to realize that even in the best of the situation, this is going to close at the very end of the day. And remember, the closing date belongs to the vendor. So your clients are supposed to be out of the house at the start of the day. And in fact, many are maybe still trying to move. And because banks essentially earn interest by the minute, if not the second, they tend to give the money in late in the day, in the afternoon. So this means that you may not have your clients having the keys to their new house until the afternoon, late afternoon, and even the evening. And this is when it happens at all. So there are other good reasons also for not buying and selling on the same day. So your clients may want to get in there early, do a little bit of renovations, maybe some paintings, some touch-ups, and it also provides opportunity to build in for Murphy's Law, to build in for the unexpected. And I'm going to touch on that in a little bit later. But let me tell you a story of my first real estate transaction. So I was newly married, and the first transaction I had, my first client, was my mother-in-law. And what do we have for that transaction? Well, my mother-in-law decided to buy and sell on the same day. She decided to do it on the 30th of June. And of course, that was just before Canada Day. And it was, in my decade and a half of real estate experience, it was probably the single most stressful thing I've ever gone through. And of course, my mother-in-law was moving in the same day. My mother-in-law was calling me. I was on speed dial and got call after call after call after call. When am I going to get my keys? When am I going to get my keys? When am I going to get my keys? And of course, I wasn't able to give them to her until the transaction had finally closed at the very end of the day. Now, good news is we actually did get the deal closed. I think with all of the sweat and tears that I had, I think I aged 3 or 4 years. But she remains my mother-in-law to this day. And though I certainly wasn't on that day her favorite child, I have once again regained in her eyes that I am her favorite child. But there were several months when there were no longer offers of babysitting for our kids. So let's deal with the financing issues. There are a couple of issues that we have here. So before things really heated up in terms of the real estate market, it was a pretty standard clause to put into the agreement of purchase and sale a mortgage approval clause. As more and more bidding wars came about, these got removed. And with the changes in the interest rates, it became more difficult for people to eventually close. And this actually wound up in particular of the last year or so, a lot of transactions didn't wind up closing. So what do we recommend? ideally reinserting a financing clause. But this may not be enough. In past, people would talk about getting pre-approval, and that's great. However, the pre-approval is also based upon the assumed value and the appraised value of the property. And so what you may want to do is take it one step further, making sure that your clients contact their financial institution, find out whose appraisals they accept, and then getting an appraisal for the property that's done. Therefore, that they know that, and the bank would accept the appraisal within a certain period of time, and that then they can get pre-approval based upon that appraisal rather than an assumption of the appraisal of the property. So another issue that is very, very topical deals with carry-on claims. And for those of you who may have seen it, it was in the news yesterday that Tarion is saying that they're going to be $90 million in new claims, which is going to be the largest claims event in their history. And these claims are for builders, developers who took deposits and yet are not closing. Many of them are walking away from the projects entirely. They may have gone into receivership, into bankruptcy. It can be very, very problematic. Now, the good news is that if it's a Tarion builder, there is deposit insurance. The bad news is the deposit insurance is capped at $100,000 for resale homes. And that is, or new build homes, I should say. And that is not very much. And many people go through that very, very, very quickly. And so what is recommended is that that any deposits given to Tarion get bonded off. I can tell you a situation. We had a client had an APS with a builder, and this was pre-2018. So at that time the limits were only $40,000. The builder got into trouble, and that we then needed to go and to try and recover the deposits. Fortunately, we were able to get an award for an arbitrator, and my client did get back an award for the entirety of their deposit. However, this event took years. And so you want to, in a situation, if you can have the deposit bonded off, you can make things much, much, much easier and faster for your clients. So in terms of things to do with this, if you're a vendor, and again, we've gotten to the situation where some purchasers are not able to close. I've dealt with a number of these over the last year. Last summer, I was simultaneously dealing with a vendor who was a situation where I was representing the vendor, the purchaser couldn't close, and at the very same time, I was dealing with another property where I was representing the purchaser, and the purchaser wasn't able to close. If you are acting for the vendor, in a perfect world, you have language put into the agreement of purchase and sale that ensures that the deposit is forfeit if the property does not close. And this could help reduce the possibility of the lawsuit, or the length of the lawsuit, or the gravity of the suit eventually. If you are a purchaser, one thing that you may want to do is have language put in the agreement of purchase and sale that allows for the agreement to be assigned. Now, why would you want to do this? Why would you want to have the potential for an agreement assigned? So let's take a situation. A new couple is purchasing a property and they don't quite qualify for the mortgage that they thought. And the interest rates have gone up and they're not quite there. So they think to go to mom and dad, father-in-law, mother-in-law, and said, hey, can you help us out a little bit? And by going as a guarantor on the mortgage. However, a lot of banks are reluctant to do this on the basis of a guarantor. They, in many cases, want the parents to be an actual party to the transaction. If you are dealing with a new build, a lot of the new builds have prohibitions against assignment, or in the alternative, that they charge enormous fees to have the agreement assigned, to have a party at it. So by having the ability to add a party in the agreement of purchase and sale, you could reduce or eliminate these potential fees for your client. So let's talk about issues of incapacity and death. First of all, this is going to be the first time I touch, and not the last time I touch, on KYC or Know Your Client. It is so critically important that you know who your clients are. And you find out, is there going to be an issue where you need to have a power of attorney? So let me give you an example. As everybody I'm sure knows, if we are dealing with a matrimonial home, if both spouses are not parties to the transaction, the non-party is the consenting spouse and needs to consent to either the purchase or the sale of the home. So I was dealing with a situation, had a client come to me just before the closing, very, very close, a few days before the closing, and they were purchasing a property. I was told by the mortgage broker that my client, she was single. She was not married. Okay, came in a few days before the transaction, and we were going through the KYC, and I found out that no, in fact, she is married, and that but that she wants the property to go into her name, not her husband's name. Fine, but we need to get the consent of her husband for the transaction, especially for the mortgage. Except for her husband isn't there. He's a professor in Tehran. And all of the mortgage documents had already been prepared on the basis of what the mortgage broker had submitted. Now, thankfully, there was sufficient time to get things amended and to get the documents signed in Tehran, and the KYC is done in Tehran. This was pre-COVID, where things weren't as easy in the world of Zoom, but it was a very, very stressful situation. You may have a situation and where one of and if you're dealing with the vendor, one of the parties to this may be going away on vacation during the closing. This is when we may want to look at getting a power of attorney established before they leave, preempting any possibility of having a problem. So let's deal with the most difficult issue, is death. And I'm going to deal with this from two separate ways. One, dealing with a death of a party, and then the other way is dealing with where the party to the transaction is an estate. So I dealt with a particularly tragic situation a number of years ago. My client was actually murdered a few days before the transaction was due to be completed. What we did is we immediately contacted, communicated this to the other lawyer involved, and the two agents communicated it to each other. We informed them about the situation and that we needed to have an extension in terms of closing. They were very reluctant to give us an extension. I think we only got an extension of about a week. And then we were scrambling to try and get probate. And what I did was I channeled the immortal words of Sergeant Pinsett. Sergeant Pinsett was, of course, my drill sergeant when I was going through basic officer training in the Army. And what we did is we moved with a sense of urgency and purpose in order to get the probate application done. And I think it may have been an actual record. I personally went down to the probate office. I explained to them that my client had been murdered, that his widow would be forfeiting her deposit and would be in an extremely precarious financial situation were the probate not granted immediately. Fortunately, the probate court was absolutely superb and they granted it right away. And we were able to close the transaction successfully for my client. And what we were doing in that situation, in the most difficult of circumstances imaginable and the most trying and traumatic situations imaginable, we were able to reduce slightly her burden and to reduce the stress just a little bit and allow her to focus upon grieving. So let's deal with the other situation. Let's deal with a situation in which an estate is the party to a transaction. Now, this is going to, in almost every case, not necessarily every case, but almost every case, the party is going to, the estate is going to be the vendor. So what you want to do is you don't want to list the property until probate has been granted. There are situations in which probate is granted very quickly, and there are other circumstances when it can be very slow in terms of the probate application. Things are much better now, but during COVID, it was taking a long time for probate to be granted. You don't want to list a property and then not be able to sell it, or have the uncertainty of selling by a certain date and not being able to meet that. The other thing you want to find out is it one executor or is it an executrix? Is it in fact a professional executor or trustee, such as a trust company, or are we dealing with a situation in which there could be co-executors? If there are co-executors, what is the relationship like between the co-executors? So this past summer, I had a situation in which there were two siblings involved. They were co-executors for a house involving the sale of their parents' house. And they had spent years in litigation between them. And we were just there to do the transaction. However, the level of animosity between these two siblings was extraordinary. And there was a situation in which there was not even a dispute about a few $1,000s of expenses, but there was just hadn't been clarified yet. And one of the siblings decided that they did not want to close the transaction and were willing to hold up everything if they didn't resolve the issue right then and there in terms of these expenses that had been incurred with respect to the property. This was also happening at the same time that my wife and I were isolating downstairs in our basement because we were suffering from a really bad bout of COVID. And I was having, frankly, difficulty talking without coughing horrifically and dealing with the situation. In the end, we were able to prevail upon our clients and get them to sign the necessary documents in terms of closing the transaction, but it was a near run thing. And again, if you know these sort of issues are in advance, ideally, if you're able to communicate things, it makes it much, much, much easier. Communication is key, and knowing your clients is key. We've talked about incapacity and death. Let's discuss the impact of disasters. So obviously, we have the COVID situation, and that changed not just the real estate market, but it changed the entire world. And this was something that for a while, transactions were paused while we were trying to figure out what to deal with it, and transactions were halted. Indeed, the entire world was halted. However, we were able to adapt and then continue to process transactions. What about other disasters? So I had a situation a number of years ago that my clients were purchasing a property, and they wanted to, and they were really keen on having an outdoor pool, and they were keen on building the outdoor pool. They had a young child. The idea of swimming was tremendous. So in a good news that a few days before closing, not only did they have a pool in the house, they actually had an indoor pool. The bad news was it was because there was a flood in the basement, and the basement was 2 meters underwater. What do we do in this circumstance? Well, fortunately, we spoke to our clients before they signed the agreement of purchase and sale, and we ensured that they did not try and buy and sell on the same day. So this gave us a little bit of a cushion in terms of what to do. So there was enough time that our clients were able, or that, the vendors were able to remove all of the flooded waters from the basement, and we were able to go there and assess the damage and do an estimate in terms of the damage to the house. We then were able to make an adjustment in terms of the purchase price that took into effect all of the damages that had been sustained. This is one of those reasons why you don't want to buy and sell on the same day. You don't know what's going to happen. You don't know when Murphy is going to strike with his law, but you are just going to give yourself a little bit of cushion in case what Donald Rumsfeld so notably called the unknown unknowns happens to strike. If you are dealing and your client is the vendor, what you want to do is you want to speak to them to make sure that they maintain the insurance coverage under their property. If you're in a situation in which they have actually moved out a few days before the closing, make sure that they obtain the insurance that will also deal if it is vacant. This again is critical. And because one of the things is that once the agreement of purchase and sale is signed, the vendor is holding the property in trust for the purchaser. We are going to turn right now to title issues. And I mentioned before the KYC, I'm going to mention it again and again and again. If there's one thing that I could leave you with today, it is how critically important it is to know your client. Before engaging in the process of signing the agreement of purchase and sale, even looking for properties, find out what your client wants to do. And this is on the purchase side. Is your client wanting to build an extension? Do they want to build a pool? Are they looking to completely tear down the house and build a new house? Why you need to know these things is to find out if there are going to be issues in terms of potentially easements affecting their ability to do what they want to do. If there is, for example, lines from Bell Canada going through the backyard, this may affect their ability to have that pool they dreamed of. They may not be able to do it. You could have situations, there could be easements running down the side of the property that, again, affect if they're looking to build an extension or entirely new home, that will prohibit or restrict their ability to do that. I had a situation in which a client of mine was purchasing a property for looking to redevelop, and they discovered that there was an easement on the property that would greatly impact their ability to develop the property. Fortunately, in this situation, there were provisions in the agreement of purchase and sale that allowed for the examination of the property in terms of title before it became firm and binding. And in this case, our client did not proceed with the transactions. But an even better way is to do a search on title before and know what the client is getting. So you have other issues that can happen. So for example, a construction lien can come on. This is one of the reasons why you would like, and is so beneficial to have title insurance on the property. So construction liens don't tend to be as big an issue. They do sometimes come up just before closing, but if, particularly when the amounts aren't that great, one of the parties, the vendor, is able to go to court and is able to bond off the lien by paying money into court. Then they can go and fight about it. There are other potential things that can crop up, some gremlins. There was a situation in which our client was a mortgagee. They were providing the funds to purchase a property that had gone power of sale. The transaction closed. We registered the mortgage. Everything is seemingly fine. However, about 40 minutes after the mortgage was registered and the transaction was closed, a certificate of pending litigation was registered against the property from the former owner of the property, disputing the validity of the mortgage transaction or the power of sale from the prior mortgagee. Fortunately, our client had title insurance, and title insurance paid for the defense for the title, and that we were able to successfully bring an application to the court to remove the certificate of pending litigation, and my client was not out of pocket a single farthing. These are one of those things where it's absolutely a lifesaver to have title insurance on the property. But bear in mind that title insurance does not cover everything. So if, for example, there is already a registered easement on the property, and it is there and it is known or knowable on property, and then your client can't do what they wanted to do because of it, they can't build the pool that they had envisioned, that would not be covered. Now, communication is so critical. And bear in mind that you are the expert and your client is not. So knowing what they want to do and what they can do and what the property is and communicating this to your client is critical. For our house, we sit on a ravine lot and we have a tremendously deep property that is really exceptional for farming mosquitoes and is great for raccoons. But there's a lot of the property that is unusable. And in terms of our developing the property, because we're on a ravine, we need to deal with the conservation authority. So it is certainly more of a hurdle and a burden in terms of any development for the property. Now, I happen to be a real estate lawyer, so I was well aware of this. However, your client may not be a real estate lawyer, and they may not be aware of some of the potential limitations or hurdles that they may need to go through if they have a ravine lot, for example. So this again comes back to knowing your client, knowing what their intended use is. So one other thing I would just add on the previous slide is about home inspections. Before things really heated up, there was typically a provision, a lot of purchase and sales that talked about the home inspection, successful completion of a home inspection. That went out of vogue. So, and because when there were bidding wars, but what you may want to do is have a home inspection done before you put an offer on the home. And what you don't want to have is any surprises coming up from your clients. Now I'm going to deal with the potential for common malpractice errors. This information is coming from LawPro, and which is the insurer for all lawyers. These are common to lawyers, but they're also common in terms of to realtors as well. And one of the biggest issues, or the biggest issue, comes down to communication. So not informing clients about land use restrictions, overlooking the surveys, not discussing this with your clients, failing to learn about the client's future plans for the property. So it comes down to, again, KYC, KYC, KYC. Know what your client is going to do and then communicate that to your client. Let's talk about several tips for successful closing strategies. Your client's purchase of their home is the single biggest transaction that they will make in their lifetime. They don't like surprises. Surprises are bad. Unexpected is bad. This is why you want to minimize the potential of a surprise. Conduct your pre-transaction due diligence. Do this right from the moment that you're retained. Collaborate with a real estate lawyer. Have them examine title issues with them. Explain the potential title issues, or have the lawyer explain potential title issues to the clients. And again, title insurance is enormously beneficial. Now, though many of you may be familiar with Malcolm Gladwell, a Canadian author, he's written a number of books. One of the things that Malcolm Gladwell talked about is he talked about the difference between social norms and business norms. And he did a study and a case study upon physicians and physicians who were sued by their former patients, and found out that there is little to no relation between the competence of the physician and the actual likelihood to get sued. And it came down rather to the communication that doctor had with their patients, and frankly, how congenial they were and what sort of relationship that they had with their clients. And I'm going to extrapolate this a bit and talk about the potential for problems after closing. When my wife and we purchased our house, we came into the house. In our fridge was a bottle of champagne. There was a little bit of a fruit basket. There was a beautiful card from the vendors saying, "We hope you love this house as much as we did." And almost a decade and a half later, I still think of that and have a smile. And that made me feel fantastic. There was no problem in terms of our closing of it, but had there been a post-closing issue, it would have made us much, much less likely to try and engage in litigation afterwards. There are situations in which vendors may, for one reason or another, not leave the house in pristine condition. There may be garbage, there may be refuse, there may be all of these sort of things. And something that all of a sudden puts a sour taste into the purchaser's mouth makes people much, much, much more likely to engage in litigation. I am dealing with a case right now. There was some post-closing issues, but the closing was incredibly difficult, and my clients were challenging, shall we say. And because of that, the purchasers are now suing the vendors for something that ought not to have ever gone to trial, but could have probably been headed off the pass had the transaction gone a little bit smoother, had there been a bottle of champagne, and had things been dealt with in a little bit of a different manner. So I'm going to talk for a minute or two about MASTERRE. And MASTERRE, we are software that is real estate transaction software designed for real estate brokerages. We are specifically designed for the Canadian market and tailored to Canadian brokerages. We look at a few of the issues that are facing real estate brokers. Many brokerages are using Excel or fillable PDFs for their trade record sheets, and this leads to errors and duplicate entries. MASTERRE software has everything as a cloud-based software, which can help reduce paperwork by over 50%. Here's an issue: trying to coordinate the transaction, the invoicing, the trust accounting, communication with the law firms. It's time-consuming and very challenging. With MASTERRE, you can approve all of the deals on our cloud-based software, generate commission statements, and reconcile your trust accounts. There are many products that deal with transaction management software that are not designed to comply with Ontario regulations and legislation. MASTERRE was designed by Ontario real estate professionals for seamless integration and compliance with all of our data hosted in Canada. So that concludes our presentation, and I'm just going to turn to the questions right now. And if anybody has any other questions, please don't hesitate to ask. So a question was asked if I could tell more about bonding of a deposit. So in terms of bonding of a deposit, what you want to do is there are companies that will provide a bond and will insure your deposit that is given to a Terrion builder. And this will be not free. They'll have to pay for it. However, If you're in a situation in which you're making a substantial investment, you want to make sure that should something happen to the builder, if there's a receivership, that your deposit is fully covered. So there's another question about Terrion, and somebody asked, how can I find out if somebody is a Terrion builder? Terrion has a website, and you can go on to Terrion's website and you can look up what the status is of any individual builder. Bear in mind, in terms of this, to be very careful to having the exact company name. So it may very well be that the vendor or is a numbered company operating 1, 2, 3, 4, 5, operating as Crazy Eddie's building. But there may be different Crazy Eddies out there. So you want to be very, very specific about what the name of the corporation is. So, okay, those are the questions that we have had for today. Oh, wait a second. Sorry, one more question just popped up, talking about title insurance. So asking what title insurance covers and what it doesn't cover. So title insurance goes to covering what they call good and marketable title to the property. So, for example, if there is a Planning Act violation, these are typically covered by title insurance. If somebody puts a certificate of pending litigation on the property, now we earlier dealt with and we talked a little bit about issues related to estates. But you could have a situation in which a property is sold by an executor, and then and there's a fighting amongst the executors, and one of the beneficiaries challenges the executor, and that tries to put on a certificate of pending litigation on the property. Again, these are the sort of things that title insurance would cover. They would not cover things like registered easements on the property. Title insurance would not have covered, for example, the flood damage that happened to the property that my client was purchasing, because that is a different type of insurance. They call it P&C, property and casualty insurance. So it is, if you're representing the vendor, it is important to make sure that they do have insurance covering the property in case the unexpected happens. So, are there any other questions that anybody has? Well, thank you everybody for joining us today for this little lunch and learn. We are going to be we're going to be back next month, and we're going to be joined by my good friend Bob Adorian, and it's going to be on the 21st of March. It's going to be at noon, and we're going to be dealing with the agreement of purchase and sale. Oh, and I was just about to wrap up, and I just got one more question, and he was asking about the closing dates from the first day of the month and the last day of the month, and just wanting to understand a little bit more about this. So the reason why you want to, if possible, avoid the last day of the month and the first day of the month is just because of the volume of transactions that are happening. I mentioned earlier, 35 to 40% of transactions in a month are done on these 2 days. If your client is purchasing the property for cash, then it's not a big issue. It's not a big deal. But if they're requiring bank financing for the property, banks' back offices can be overwhelmed during this time. And so allowing for the possibility that they're just not able to get to the transaction in time. This is also complicated if there is something that changes slightly with it. For example, you are trying to got in a situation where you need to add a party, you need to add mom or dad to it. That may take the mortgage application process, put it to the back of the queue. It needs to be reprocessed. And because there are finite resources in the banks at this point in time, that so many transactions are all trying to go in that time, they may not be able to get to it till a day or two later. So this is why it's something that you want to avoid if possible. It's not as bad as before or after a long weekend, but it probably the worst day to close is the day that I closed with my mother-in-law on June 30th. And I think it was a Friday, June 30th, too. And so that is what you do not want to do. And of course, buying and selling on the same day as well. That wraps up for our presentation. If you have any questions, you can contact us at support@masterre.ca. Masterre.ca is our website. This will be posted online. Thank you very much, and I look forward to seeing everybody at next month with Bob Adorian. Have a wonderful day.